Probably going to take about 30 seconds to go on YouTube. All right, we're live on YouTube. I'm going to admit everyone now. All right, we are live on the Ferraro versus Sedor matter.
All right, Judge Bogaard here. Hopefully everyone can hear me. This is the Ferraro Sedor matter, MRS-L-2592-19. And if everyone could identify themselves.
Fred Ferraro.
Alex.
Good afternoon, Your Honor. Irina Elgart, Fox Rothschild, on behalf of John Sedor.
Okay.
Good afternoon, Your Honor. Catherine Schwartzstein on behalf of Fred and Patricia Ferraro.
All right.
Good afternoon, Your Honor. This is Kevin Curran representing myself.
Okay.
Good afternoon. This is Doug Tanchak.
Okay. Is he representing himself pro se?
No, Doug Tanchak is the representative for John Sedor, the attorney.
Okay, I don't need appearances from non-attorneys or individual parties, and make sure their mics are muted. Okay.
Good afternoon, Judge. I'm not sure. I think I was talking over Irina earlier. This is Alex Claps from Heyman and Fletcher on behalf of David Ferraro and his associated companies.
Okay. Is the entity still able to function and run at this time?
Hi, Your Honor. This is Catherine Schwartzstein. So I spoke with my client, and Fred is on the line, but I spoke with him before this call, and the entity is still running. I think it's one of those essential services that they're allowing to stay open so that if there's medical professional or other professionals or other people that they can bring their kids in for childcare. So they're still running, but obviously people are pulling their kids out, and they're in a difficult situation right now.
Yeah, it's certainly not evidential, but there was an editorial in one of the papers imploring the governor to shut down child care or daycare facilities. So just it's got to be on everybody's radar what's going on.
Your Honor, just yesterday, Governor Cuomo of New York declared child care centers to be an essential business.
Okay.
So that was the New York declaration, and I hear from good source that something similar will come out for New Jersey today or tomorrow, which presumably would then include child care facilities as an essential business, as Catherine has mentioned.
Okay. I always think of myself. My big issue is whether or not I will be allowed to come into the courthouse on Monday. That's an issue that's up in the air. I am on my bench right now, talking to you through modern technology and a computer on the bench with the assistance of my court clerk, Matt Lopriano. But there is a chance that when you next talk to me, if and when that were to occur, I would be in my home. So I'm hoping that's not the case. I'm hoping that I would be allowed in the building, but we shall see. It'll certainly be interested if all of the judges are barred from entering the courthouses, because we obviously have a very, very skeleton level staff at this point. All right. Starting with the Ms. Schwartzstein, have the accountants at the very least spoken to one another?
Yes, Your Honor. So there was a call. I don't recall the date. I think it was March 11th, or I believe it was March 11th. We had the call. So with them is the accountant for John Sedor, and I guess for David Ferraro. And Ms. Claps, please correct me if I'm wrong on that. But anyway, they did speak with Wiss, who's the accountant for Alfred and Patricia Ferraro. They had a couple of questions regarding the documents that we provided to them. We are trying to address those questions. We haven't yet responded to them. But it's our position that none of those questions are so material in nature that they warrant a preliminary injunction. There may be some matters that are still outstanding or things that need some additional support, but we, in all of our documentation, I think that we've provided 99% of what my adversaries have asked for. We've shown them what all of the outstanding liabilities are. We've traced all of the capital accounts, given a capital accounting. We gave a break-even analysis, and we very clearly showed that Patricia Ferraro was giving money every month or loaning money to the company every month and then paying herself back, but that there was absolutely no fraud in that, and that those weren't disbursements or capital disbursements or payments. Those were just repayments for loans that she was giving to the company to keep it afloat.
Oh, okay, before I get everyone else in or involved to talk about it, the issue, let me just ask Ms. Elgert, on January 15th of this year, you sent a note to Larry Choder at about 11:58 a.m. and you said, all right, I represent John Sedor, a member of the business entity, and I understand that you're retained on behalf of the entities and the like. So let's talk. Let's set up a meeting. And you gave him various times and the like. And you obviously knew or should have known that Mr. Choder was not the in-house accountant for the business. That's not his game. Everybody knows that.
Well, I was directed.
Excuse me. Then on January 16th, one day later, a little bit more than a day, because it was just 4:50 p.m., you canceled the meeting. Why did you do that?
Because we were advised that they were forensic accountants and that's what the role was. Because I had requested.
You didn't know Larry Choder from WIS was a forensic accountant? Are you not a partner with Eric Solar?
We were directed to contact him by Ms. Schwartzstein because that was the representation that was made. And I think there were other parties on this call that can verify that information, because that's what we were told. And once I found out that Catherine had authorized me to call him if that's the issue here. But I think that once I found out he was a forensic accountant, and in that role, I should say, then that's where I said, okay, well, the order provided for an accountant on behalf of the business in order to clean up the books and records, because that's the problem here. And that remains the problem here.
But we have two professional accountants. We're talking to one another. What's the emergency?
The problem is that it continues to be the same problem as before. We are given information, but it's not valid. For example, we shouldn't be learning after filing the complaint that there are default notices that they are receiving for the franchise, the royalty payments of 80, and I believe it's still outstanding at 80,000. It could have changed, but we haven't gotten any updated information. The real estate taxes are still in arrears. We didn't know the amount. In terms of the unrecorded liabilities, we never were advised of the unrecorded liabilities. And as a matter of fact, there is an allegation by Pat and Fred that they each are still owed with regard to wages, I understand, of $70,000 each is what they're alleging. And that is based on unsubstantiated, from what they're saying, hourly records of they're supposed to be paid $20 an hour. And that's not what the operating agreement says. It's the professional services that says that they get paid $20 an hour if, for enrollment type duties, not during the construction period. We have not been given any access to the construction bank account itself. RJS Construction, as you know, was the contractor, the general contractor, and that contractor signed a certification that all the subs have been paid. And that was in 2018. And yet we're still receiving these unrecorded liabilities, one of which was $120,000 that is allegedly owed to Pat's brother, Jeff Felber.
Your Honor, I could address every single one of those
But
points.
they're alleging both Tanchek and the brother were stealing money, right?
No.
And
that's not what
yes,
they're alleging.
yes,
Yes, they are.
and
They're alleging, what did they do for $10,000 a month? Right? What did these guys do for $10,000 a month?
well, and
What
Your
did-
Honor,
Why it was Fred, I'm sorry, they engaged them to do work. I don't know what they did because, quite frankly, Wayne Tanchek has passed away.
but
Okay.
Your Honor, just
Oh,
to
that's
speak
not
to that, this is,
something that, but I think that Dave Ferraro could speak to it.
But don't,
yeah, and
all
you're-
of you guys, let me just start with two basic premises about this case. This is a classic, he said, she said, they said, back and forth. It's like the whack-a-mole game. Every time you think you get a hold of one little issue, three more pop up, okay? This is not order to show cause material. I can't rule in a summary fashion on a case like this. I have competing affidavits left and right. There's no evidence that, and now we have two experts involved that are going to have to really kind of dig their heels or dig their minds and analytic processes into this case. But I'm not seeing what's going on in the country right now is an emergency, right? What's going on in this case is a family business dispute. There was no jury trial, right? Asked for in order to show cause. This is a chancery case. And, you know, whether I made a mistake, you want to say I made a mistake, whether I thought I could solve it or the like, I entered the order and said, okay, let's see what's going on here. But I looked through the prayers of relief. I think you have to get to the 18th prayer for relief till it's anything arguably related to the law division. A receiver, chancery. An accounting, chancery. They're all chancery.
Well, I think there is going to be damages here. But the
Well,
fact is,
Chancery.
The
well,
defendants
so can
have
the law,
already,
I think that there's
a jury
concurrent,
demand has already been
jurisdiction.
submitted.
right,
But
and there's
not
concurrent
in order to show
jurisdiction.
cause.
right, a jury demand you don't do a jury demand for an order to show cause. And I could, Your
Did
Honor,
you
I
say
could
anywhere in
address
the
every
papers
one
that
of
they
those.
Well,
used a
if
jury
I
trial?
may, my experience has been that whether it's Chancery or Law Division, if I file it in Chancery, sometimes it gets transferred over to the Law Division. But the Law Division seems to have more expansive jurisdiction, and there's concurrent jurisdiction. So with regard to there being a choice, I don't think it matters one way or the other.
Judge, if I may, this is,
I've never heard of a case like this being tried in the law division, to be honest with you.
Well, I have.
The judge made a mistake. Can I tell you? Yeah, yes, counsel.
thank you, Judge. I just wanted to say that I have come to this case a little bit later, so I have the benefit of having heard from the experts first. And what has become clear to me from both Mr. Choder's certification and then subsequently the phone call itself is that his entire analysis is comparing what Fred and Pat told him to what Fred and Pat told him in another form. He hasn't been able to actually dig in and investigate the books. Nobody.
That's not true. That is not true at all, Your Honor. I highly dispute that. And I can also address each one of the points that Irina made. This is Catherine Schwartzstein. That is not at all true. We have produced over 11,000 documents. My experts have spent tens and tens. They've spent hundreds of hours going over these documents. The plaintiffs want to make it look like there's one or two outstanding issues and then the whole thing gets thrown out. First of all, as far as the construction costs go, Wayne Tanchek and David Ferraro were managing the construction. They had access to all of the documents, more so than my client, Fred Ferraro. So for them to come back and ask for things, one, only shows their either fraudulent activity or complete failure to act in their role. Because if they can't substantiate, we gave them a whole spreadsheet that was provided by the bank. All of this was done by an SBA loan, Your Honor, where each and every payment during construction had to be approved by the bank before it went out. So for them to even make allegations that my client committed any kind of fraud or can't account for the construction costs, frankly, as you can tell, it infuriates me. Because, and number one, this is not something that should be talked about on a preliminary injunction. These claims that they don't know about late real estate fee things and franchise fees, my clients have been telling the other members that real estate taxes are late and that the franchise fees are due for years. They've been aware of this for, at this point, at least a year.
Well,
So
let
they
me,
want, yes,
let me ask
interesting
plaintiff's
that we-
counsel a question. How much money is it do you understand that as purported construction managers, David Ferraro and Fanchak received?
If I recall correctly, Your Honor, I don't have the full file in front of me because I'm obviously working from home at the moment. I believe Mr. Ferraro received approximately 60 and is still owed 110 because they stopped paying him at some point during the process. He was to receive $8,000 a month as construction supervisor.
And
if I may, Your Honor,
Yeah.
the tan check that you're referring to is another individual than the person that's on this line. So,
way, I understand.
and John Sedor was somebody who was an investor. So Wayne Tanchek, the contractor, is separate and apart from the investor, John Sedor.
but he was acting as his attorney, in fact. He was
No,
still
he
John
wasn't.
Sedor's attorney, in
Not
fact.
till, nope, not until 2018. And that is in an email to Fred. So I think that that's something that needs to be very, very clear here.
Well, it's listen, it is described on my triage list as a case that is one hot mess.
Well, can I,
But there's,
if I may, Your Honor,
don't
can
I
I just,
have to basically find, at a heightened standard to issue any
Well,
rule at this point?
well,
This is
can I
summary
just back
action.
up for a moment? I understand that the circumstances that we're in right now clearly are emergent. But at the same time, these are cases where if you have somebody who's not giving you the information and they are the ones who have the information and you keep asking, right?
Your
There
Honor.
were several, excuse me,
One
there
at
were
a
several
time.
requests. There were several requests. And only after we filed the complaint with the order to show cause was there any movement. And that movement was because Your Honor entered an order requiring them to produce documents. If they had,
Your Honor.
excuse me, I'm
Hey,
talking.
What is
And
it about one at a time that, Ms. Schwartzstein, you don't understand? Before any attorney talks, I want there to be a 1-second gap and you identify yourselves by name. You can continue, Ms. Elgard.
Thank you. So we have here a situation where the only reason we have these documents is because of the court. We have a problem here, and it's still a problem, and it's going to be an even bigger problem. I don't want to confuse the issues here, but the fact is that the books and records are a mess. A mess is the best way. That's the technical term here. They're not maintained in any semblance of order. What we were asking for and still asking for is for an accountant to come in and get the books on an accrual basis. There's nothing here that why Fred and Pat need to say that they don't want that to happen raises a lot of red flags. There is an admission on their part that the tax records were not correct. The tax records had multiple problems. I mean, we're talking about tax fraud here, potentially, okay? And that's not something that should be taken lightly. And they need to be amended. The books and records are like scrambled eggs at this point. Okay,
Your Honor.
there's a huge problem and we need it fixed. And that's why we're here. That's what the LLC Act, that's why Fred was taking a salary at $55,000, or thinks he's entitled to a salary of $55,000 a year. That was his job. He's not capable of doing it. We don't have any certifications that even say that he's capable of doing it. We only have Pat's certification to say about her experience in the child care area, but nothing from Fred. And I can tell you that based on the conversations with and company, they are still waiting for documents and substantiation, despite some of the representations that they have made. And on top of it, apparently there was a break-even report that Fred and Justin or Jordan, one of their sons, who is now being paid by one of the operating entities, had prepared a break-even report. Now, this break-even report is a joke because there is a TBD for unrecorded liabilities. Okay, there's to be determined and huge liabilities we're talking about. So, in order for there to even be a break-even, allegedly, the company's going to break even by July, which only means that they can start paying the unrecorded liabilities. And why are they unrecorded? And we don't have the agreements. We don't have a loan agreement that's supposed to be between the company and Justin Ferraro, even though he's getting paid 8% interest on a loan. I mean, I can go on. There's a check that was deposited.
Your Honor, can I?
For $240,000.
Here's what we're going to do. Let me, before I come back to Ms. Schwartzstein, we have at least two other individuals on the line who the court will allow to speak. Mr. Kern, Ms. Claps. I don't know if there's any other counsel maybe on the line. And I don't mean to disrespect any of the individual parties who are represented by counsel who may be on the call, but it wouldn't be appropriate for me to allow them to talk. I'd have to first swear you in, take testimony, and that's not fair because we didn't have adequate notice to the other individuals. So that's why I'm doing things the way I am, and that's why I have things on mute. I almost said moot. Caught myself, right? Let me hear from Ms. Claps and then Mr. Curran, and then anyone else who's a attorney of record, or if there's a party of record who's self-represented, who's filed a pleading, they may address the court also. All right, first, Ms. Claps.
Thank you, Judge. My concern for the purpose of this hearing, because it is an emergent hearing, a summary hearing on very limited emergent issues, is to make sure that there is a company still functioning at the time that we get to the remaining issues. The long-term fixes, the long-term debts, I understand that that's not going to be able to be taken care of today, and nor should it. However, there are three individuals purportedly in charge of this LLC, none of whom seems to understand fiduciary duty, none of whom seems to understand how to get the amount of tuition that had been coming in, obviously prior to last week, was exceeded the regular monthly operating expenses of the business according to their spreadsheet, and yet every month additional arrears and additional late fees and additional payments were accruing that need not be accruing. And I don't know why in 18 months of operation they've not been able to get their act together, but it's truly alarming and concern at this particular emergent stage is that there's not going to be a business left to deal with everything else if we don't put somebody who knows what they're doing in charge. It seems to me, I'm not a business expert and I'm not going to pretend to be, but those three individuals are doing the job that one well-qualified individual should be able to do. They're not the ones, scheduling the staff and running the actual day-to-day operations of the daycare. This is just the back office, for lack of a better term. And so we're just asking that Your Honor put somebody in charge, a neutral party, to keep things going while we go on with the rest of this lawsuit.
All right, Mr. Kern.
Good afternoon, Your Honor. Thank you. This is Kevin Curran. So looking at Your Honor's order to show cause, we're only looking at a couple of issues on a preliminary injunction. Item A, allowing for another qualified financial or accounting professional. Item D, enjoining or restraining Fred and Pat from dissipating any of the property or assets of the professional services or management LLC. Requiring Fred and Pat to turn over key passwords, credentials, etc., and then possibly removing Fred and Pat as signatories for the accounts. So, we're not yet deciding all of the bigger issues in this case. And for me, the fundamental thing that has been an issue is really just the aspect of honesty or the lack thereof on behalf of the defendants, Ferraro's. And as Ms. Elgaard had pointed out, the 11,000 pages of document production was only produced at the requirement of the court and not prior thereto. And so, that raises one flag. The other thing is, as I stated in my opposition certification to Fred and Pat's, what they refer to as their own order to show cause, even though they didn't file notice of motion or pay a motion fee, they've requested their own entry, which is procedurally deficient, as I pointed out in my reply brief. But just moreover, they've not followed Your Honor's requirements in the order to show cause that was entered back in December. Right now, I've been only given access to the Carney bank account online accounts. That's the only password and user ID that has worked. The only one that I've received is the what's called Tuition Express or ProCare, and that combination of user ID and password has not worked for me once in the times that I've tried to log in. I've requested from Catherine Schwartzstein to receive the additional login information, and I've gotten no response from her. She just ghosts me, so she hasn't been replying. And so we don't have access to all these I don't have access to the QuickBooks account, for example. Now I understand that possibly Witham may have access to that, but I am not working with Witham, and so I've specifically requested independent access, and I've even mentioned it in my reply brief, and yet I still have not gotten anything. I mean, how many times do I have to ask is, I guess, the bottom line. But as I pointed out in my reply brief, there are so many instances of failure to comply with Your Honor's very straightforward order to show cause entered in December, that the issues are really one that go back to the honesty and the ability of Fred and Pat to move forward, and the self-dealing that's been going on, as was itemized numerically. Your Honor's order was very explicit in that the parties were none of the parties, including, Fred and Pat in particular, as they've had historic access to the bank accounts, none of the parties were to dissipate any of the company assets. But even as Catherine Schwartzstein has mentioned, Pat has withdrawn company money from the bank account repeatedly, and even just this morning took out $32,000 in cash from the company bank account. And once the money is in the company bank account as a company asset, she's not at liberty to just withdraw it just because she feels the need to reimburse herself. It's a company asset that needs to remain in the company account for use for company activities, one of which is we still haven't paid the mortgage for this month, according to the past due notice that literally came in the mail today. So I received from First National Bank, the SBA lender, a past due notice dated March 16th, in which the real estate or the mortgage had not yet been paid. And as a result, an additional late charge of approximately $1,800 was incurred. And as was explained in my reply brief, if Pat had not been taking out all of this money and reimbursing herself for these short-term loans, which as a residual claimant, she's not entitled to do because she falls to the very bottom of the pile in terms of creditors, the money would have been in the account to pay the mortgage on time each and every month for the last year. And we would not have incurred now close over $35,000 in late charges simply because of the timing, purely a matter of timing in Pat's withdrawals. And so the issue here really goes back to, I don't see that the parties can trust Fred and Pat in their duties that they've not fulfilled over the last 2 years as the business has been in operation. And that's why I think we need to have them removed from the day-to-day management of the finances as it relates to the business going forward.
Right. Any other attorneys or self-represented litigants who want to address the court before I circle back to Ms. Schwartzstein? All right, having heard none, Ms. Schwartzstein, how do you address some of the concerns or issues that were raised by Mr. Curran, saying, listen, it's kind of limited things we're looking for here. We still don't feel as if we've had all the transparency we need. And what about the $32,000 that came out?
Your Honor, there's a lot here to address. Again,
Because we're ending at around 4:35 at the latest.
Okay, there's a lot to address. The $32,000, first of all, that is one of the short-term loans that Patricia put into the company to keep. She's putting in loans, Your Honor, every month to keep the lights on. The company started in the hole. They had no available cash when they started running the company a year and a half ago.
No,
so Patricia makes.
Okay, but if she's pumping money in, so she's paying the 32 back to herself?
Yes, every month, because she has to make payroll, Your Honor, because of the way the timing works and because they haven't caught up. And by the way, they haven't been able to change the mortgage due date until recently because David Ferraro hadn't provided his information until recently. So Patricia makes.
Why would she give the money back to herself if you loan money to?
Because she needs it to live, Your Honor. Because she can't afford to make a $50,000 loan and leave the money in every month.
Okay, but so it's not. But that's really not the way you're supposed to structure those things, right? If you start a
but she's acting. There's no line of credit, which whether I filed it procedurally deficient, if Mr. Curran wants to say that or not, the reality is, Your Honor, they have no cash. So to keep the lights on and so that they can meet payroll, Patricia puts whatever is needed that month, $30,000, $40,000, $50,000, $80,000 of her own money. And then when they pay payroll and they get the tuition payment, she pays herself back for 2 weeks and then she puts it back in. And for Mr. Curran to say that she should leave that money in when he's not offering to put any money in, or Mr. Sedor isn't putting any money in, or Mr. David Ferraro isn't putting any money in, I don't understand that. Why should Patricia have to put her own money in and keep it there when no one else is doing that? And to say that they are untrustworthy or that they don't have a sense of their fiduciary duty when every month she's putting in her own money, she's acting as a line of credit because they won't give them a line of credit. And by the way, I can address each and every one of these points, but I want to say that in order to get a preliminary injunction, they have to show likelihood of success on the merits, according to Crow v. DeGioia. And according to that, usually you have to have undisputed material facts. As you can see here, almost every fact I dispute. That's one of them. And all of these claims that my clients are self-dealing, Mr. Curran filed 2 failed orders to show cause 2 years ago, racked up what he claims is $90,000 in legal fees, and then parlayed that to get additional equity in the company. David Ferraro got paid to do construction, is claiming he's owed an additional $100,000, and he's going to claim that my clients are self-dealing. My clients are the majority members of these LLCs, of this company. They're the ones who are there every single day working their tails off to keep the company going. The enrollment has, until this recent course of events, enrollment has gone from 2 students to 175 students. Their claims that we're not giving any information when we've given them bank statements, cashed check, copies of cashed checks, invoices. There may be some things that we need to follow up on, but we have given them so much information, Your Honor. I'm sorry that a password didn't work for tuition enrollment, but we've given Mr. Curran every single copy of every tuition statement since the company started. So whether or not he has online access, he's seen that information, and so have all of the other parties. And maybe it fell through the cracks on my part that he didn't have QuickBooks access, but the other 2 counsel have access to that. They have an accountant. And these claims that there's tax fraud, that's just ludicrous. When my client realized that the original accountant, Jack Blyberg, wasn't doing an adequate job, then all of this heated up and litigation heated up, and we now have WIS. By the way, WIS is in there. They are cleaning up the books. That's what they're doing. Even though they were hired by my clients, there's no reason that going forward they couldn't act as a company accountant. And this nonsense about the taxes accrual versus cash basis. Your Honor, those taxes were filed for years that the company wasn't making any money. The accountants have told me that it's an immaterial difference. It wasn't as if they were all claiming hundreds of thousands of dollars of income and now there's a big effect. That's all amortization of construction costs. There was no actual income during that period. They're making mountains out of molehills. And also, Your Honor, the business judgment rule applies here. My clients are the managing members per the operating agreement. All of these other minority members, let them be the majority members and the managers. They are entitled to the business judgment rule, that what they're doing is acting in the best interests of the company. And that's what they're doing. For all these other people to say that they're not doing that when they're there every single day, my clients, they're spraying down, with disinfectant the whole place when none of these other members are doing anything. It's an affront. Let me try to address some of the other things. The break-even report, that was substantiated by WIS. They want to pick apart certain things like the average tuition cost, whether it's $20 more or $20 less. We listed out every day-to-day operating expense to keep the lights on. We did an estimate of the average tuition. We said the maximum capacity of the facility, what it was, and then what we estimated to be what we thought enrollment would be over the summer. That's what a reasonable person would do. These are just gross mischaracterizations. There may be little pieces of information here and there they haven't gotten. But my clients are the majority members. They're entitled to be there per the operating agreement. They're putting in their own money every month to keep the lights on. They've been doing everything right. I gave Mr. Curran.
All right,
Mr. Curran
I've got
had
to, guys, just because some of the parameters of the system we're working under, let me come back to Ms. Elgard.
Thank you. Essentially, just to address a few points here. We are asking for something that, while it's called a preliminary injunction, it's extraordinary relief. I think the fact is that all we want is a level of competency there that has not been there. And that's not a gross mischaracterization, okay? That is what is happening here. And we're looking at these books and records that are in disarray, and we're being told that they did nothing wrong. That it's okay that the tax returns are wrong.
How can you say it's disarray when we could produce 11,000 documents?
Catherine, please be quiet, Catherine.
All right, guys, you know what? Here's what we're going to do. I don't believe the court has sufficient information before it today, based on what I presume to be competing expert reports. Consistent with my letters, I did not conduct a review of the Larry Choder report. But I will certainly accept the representation that there are differences between portions of Mr. Choder's report and the analysis that has to date been undertaken by the Witham accountant. But I did go through the lengthy response and cross order to show cause filed on behalf of the defendants. I did go through the papers that were initially filed in this case. And I do believe there are issues at this time with the management and running of the business. But those issues have not been crystallized to a point where this court feels comfortable removing any party from an ownership interest or the like. So the court will
Your
not
Honor.
do that. Excuse me, give me my decision. So the standard for injunctive relief has not been met under the circumstances. Should the court simply dismiss this matter and say go to Chancery? I don't know. I think that sounds like a bit of peak moment on the part of the court. So I'm not going to do that. I'll retain this matter. We'll retain it as a complex business litigation matter. And when we get some clarity in terms of things, I will send a letter out to the parties. It's a standard form letter I do on the CDLP cases. So I will retain jurisdiction of the case. What I will order at this time, both orders to show cause are, or the permanent or injunctive relief or the like are being denied. However, the court will order that a meeting take place, virtual or otherwise, between the Wiss and Witham accountants, along with Jack Blyberg, within 30 days of today's date. The Witham accountant shall provide a deficiency letter to counsel for the defendants / Mr. Choder and Mr. Blyberg within 20 days, and the parameters of the letter should be addressed. I should say, we change that, shall be addressed. This is a handwritten order. It was not preordained or pre-done. The matter shall remain in the law division at this time, and a conference call shall be scheduled by the court in the near future. The control date
Your
for
Honor,
the conference shall be 5/20 at 3 p.m.
I
Your
just
Honor,
want to jump
if I
in
may
about
say
Jack
one thing.
Blyberg.
What I need to say one thing, I'm sorry. Okay, I didn't have a chance to explain that the operating agreements and the provisions in them, like the professional services operating agreements, Ms. Schwartzberg refers to her clients as the managers. While they might be referred to as managers, there's limits to their ability to manage. And that particularly has to do with they cannot make any decisions that are major financial decisions. And that's in the professional services LLC. The major financial decisions are defined, and it's a single or cumulative payment that is greater than $5,000. So any decisions that are over $5,000, according to the operating agreement, are not being followed here. There is an entitlement for these members, all of which put money, actual cash, and are expecting, returns from it, to be able to manage together with then Fred and Pat. And they cannot make unilateral payments like $10,000 that they made to the brother in January because of some loan that we don't even have the documentation for.
And Your Honor, that's money damages that they can dispute in general litigation, but it's not something that is ripe for a preliminary injunction. But I also want to.
It's
Yeah,
not
but
okay.
I tend to agree with you, but Ms. Schwartzstein, I kind of come back to my initial reaction on this case when it came in, is that they are operating the business, and maybe it's because, as you try and lay out with the 36 plus exhibits, that that they're being undermined at every turn, which would be obviously a foolish move to do, because then everybody loses their money. Then everybody loses. Then young children and families lose.
Well,
I don't want to get melodramatic here, but again, you should be following the terms of the agreement. It's not an emergent application requiring or meriting injunctive relief that someone's not following a term in an agreement in terms of notification. Should they be doing it? Of course they should.
But
I-
Your Honor,
I've got to go
and
by the
I don't wanna-
protest.
yeah, and I don't actually want to debate that right now. I want to say about Jack Bleiberg that he is no longer retained by the company, but also he has some health issues. And I think he's been in and out of the hospital. And I don't know, I just want to put it out there that I don't know what his participation is going to be, what he's going to be able to do.
I'm putting subject to its health.
Okay.
But if the business, see, a business like this needs an accounting professional, not in-house, obviously, but you need to have an accountant that you work with because this is not, just kind of, here's my 1099, here's my W-2, and, can figure
Well,
it out.
they thought they had that. And when they realized he wasn't doing a good job, they swiftly moved in and got with, and things are turned around. And now things are cleaned up.
So
And there
who's
is-
doing, I beg your pardon.
You only need somebody to do the books for the tax returns.
Right,
They have
which
QuickBooks, right? So
Is somebody
it's something
retained
we
to
could
do
have
the
it-
20?
Right. I don't want to, again, in Your Honor, I don't want to debate that now, but I have a genuine concern when you talk about the life of this business, which is that we are now, and I did file an order to show cause about the $100,000 line of credit. And as you can tell from this phone call, there is absolutely no cooperation among the members. And now I just want to bring it up because everyone is on the call. We're going into a dire situation where it's possible that everybody pulls their kids out of that school or that daycare center for a month or two. Now, my clients don't have any available extra cash. They don't have a line of credit. There's already outstanding bills that are in arrears, and there's no way for them to make decisions because anything they do is now going to be used against them. So
Well-
I filed an order to show cause to preserve the status quo. And usually orders to show cause to preserve the status quo, they're granted more readily than other orders that change the status quo. I did.
This is
I
also
filed it.
All right, well, guys, I told you what my order is, and I'm handing it to my court clerk right now. I don't know if you uploaded it or not. It is what it is. Maybe you have to file another application next week. Maybe you have to file another application the week after that. This is unfortunately what happens when you roll into a business, you bring in some partners that maybe you don't know so well or know as well as you should. You start paying family members, whether they be brothers or sons or cousins. Businesses like this have a success rate when they're run like that and you got family members all over the place of 0. Okay? 0. So everybody's got to figure out whether or not they want this to succeed and succeed for everyone, or they want it to fail or fail for everyone. Those are really your options or choices at this time. But, again, it's like the whack-a-mole game. If I could clearly look at this and say, okay, this is definitely the situation here, or this is definitely the situation there. I see issues on both sides. Everybody's got to sit down and try and work through this. I'm not going to remove them. I'm not going to install anyone else. People should follow the terms of the agreements that are in place and that were agreed to. If they're capital expenditures or expenditures of the like that need to be run by the other members of the business, then they should be run by the other members of the business. Right now, the Ferraros, though, control over 50% of the business. So presumably the Ferraros being Alfred and Patricia, because I'm not granting that relief that Mr. Curran suggested that, well, really, Judge, here's what I owe, just because, that's a down the road issue. So they're going to win every vote. Now, whether the agreement requires a 80%, 90%, 100% approval of all payments, then maybe you've got an issue. I don't know, but you got to try and sit down and work this out. That's what needs to happen. The Crow factors, in my mind, on both sides, really haven't been met. part of that is due to the swirling tsunami that's enveloping all of our lives at this point. I really implore the parties with a facility like this, a potentially critical facility under the circumstances of our current world situation. It is important that a facility like this be able to continue its operation. However, it's not the power or province of the court to intervene on an emergent basis in every single business dispute to ensure that a business, however worthwhile, can move forward and provide its services. Sometimes it comes down to the people in the room, the attorneys, the parties, and in particular the accountants to work through these issues. That's my order. Good luck to all of you. Good luck to your families. And we'll have that order posted on eCourts. Take care.
Thank you.
Thank you, Your Honor.
Very welcome. Good luck, guys.
Thank you.
Okay, thank you.
Thank you.
Bye.
Muchas gracias.